All right, we're going to get started with the subcommittee appropriations subcommittee meeting. And we're going to start with Supreme Court. So y'all can make your way up here. Sir. Well, I tell you what, I'm gonna turn it over to you. So you go ahead and you can present to us and tell us. We're looking at this right here. So I'm going to turn it over to you. Carol, if you'll introduce yourself, please.
I'm Carol Allgood, the Finance Director for the Mississippi. Oh, right here. Okay. That's fine. Carol Allgood, Finance Director for the Supreme Court of Mississippi. This is really just hopefully short and sweet as far as our requests that we're asking for 25.
Right.
We started with the LBO recommendation, which is, this is the combined total for all of the budgets that the court has. The biggest item we have on here, the $4.3 million, that is to bring the support staff funding for the trial judges up from $100,000 per judge to $140,000 per judge.
Which is is that, we had a bill last year.
Yes, sir. It went from 70 to 100 last year. So this is
so now you're requesting to go from 100 to 140.
Yes, so we had originally requested last year for it to go up to 140. That was our original request, and we did get up to 100. That amount had not been increased for 20 years.
Right. Which
So,
we
yeah.
had, yeah.
Yes, sir.
So this 4.336 million, is that
Strictly support staff, not
right? But
for
is
the
that
judges.
that's statewide going from the 100 to the 140?
Yes, sir. Yes, sir. For 109 trial judges.
So basically 40,000 times
109.
109.
Yes, sir. Yes, sir.
And if you will, because we had some discussion, but we or me in particular didn't handle this budget last year. So if you can explain
Yes.
The reason for that.
The reason this is for like the staff attorneys, court administrators, court reporters, well, not court reporters, staff attorneys, court administrators, any legal staff that a trial judge hires. Their salaries are set by the Administrative Office of Courts. They are on the Supreme Court payroll, so they are state employees. Each judge was given, prior to last year, $70,000. Now they're given $100,000 toward that staff. And when you're trying to hire a law clerk and a court administrator, $100,000 doesn't go a long way when you add the fringe. So the counties that the judges were in were having to make up the difference for their staff. This is moving that funding from the county level to the state level. It's not raises for judges. It's just mainly moving the burden of the support staff cost from the counties to the states.
Okay, who are y'all considering support staff?
The support staff is any paralegal, law clerk, court administrator, staff attorney that works for the local chancery or circuit judge.
And is this 4.3 amount include the benefits?
Yes, sir.
Okay,
Yes, sir.
so salary plus benefits plus the whole package.
That's it. Yes, sir.
Okay,
Okay. The next column, of course, is just the PERS match because that increased up to 22.4% this past year. That's to fully fund that for the 12 months based on the current salaries that we have in place. The next one is fully funding for all of the positions for the Supreme Court and the trial courts as they exist today. That includes, this is mainly going to be on the trial judges, on the trial judge level. It's no raises for anyone, just, making sure we have adequate funding to pay all of our judges, special judges. And,
well, let's talk about that. In various conversations I've had with the Chief Justice, has mentioned about recusal, having to pay for special judges.
sir.
And when there's recusals, I know it's been explained to me that, I guess the edict is don't recuse if you don't have to.
Yes, sir.
But
Yes, sir.
there hasn't, what's been explained to me is there's, I don't know, not been enough funds or something. Is that included in here, and where are we on that?
We did get some additional funding last year in a deficit to help bring that number up to where we needed it, but that number is part of, not a lot of it. This is mainly for the trial judges themselves to meet what State Personnel Board recommended their salaries be, plus their fringe and.
So is this a raise for the trial
No,
judges?
sir. No, sir. No raises for the trial judges.
Okay.
This is just based on where they are today.
To get them up to SE squared?
Yes. Oh, it's not SEC squared, but it's what the State Personnel Board recommended and set in
personnel-
statute. Yes, sir.
All right. Well, what about the, I guess, special judges when recusals and stuff? Is that included in here?
Yes, sir. It's part of our budget. Yes, sir, it is.
Which line item is that?
It's actually part of the current funding that we already have. So it's not really, there's not a whole lot we need for them. It's, we got it up to, I want to say closer to 700,000, 800,000 appropriated this past year, which should cover us based on what we've been doing in the past. If there's a huge increase in recusals, that of course, we'll have to make the difference up, but we'll find it.
We have not needed to
But we
seek
have not.
deficit appropriations in the past couple of years for that because y'all have increased
Mhm.
that in our budget.
Okay.
Right. Any other questions on that?
Not on
particular
that.
Item?
Not on that item.
Okay. The last one, the 7% realignment, that is strictly for the staff of the Supreme Court, Court of Appeals on the lower level, the staff, not the judges. That is just basically, to help cover the cost of living. Then we have, of course, mileage and meal rates have gone up, and this is just to cover the cost for all of the trial judges across the state. They do get mileage to and from their courthouses. So this is what that's the amount for that. And of course, the contract increase is just minority, the copier contracts, the contract that we have for the law library to keep the state library to keep it up and for their books and stuff. We're of course looking, the cost of software is going up. So that's the next item. The court complex software needs to be updated, as well as the intervention court program needs to be updated and maintained. The next one, the upgrades to the court complex computer equipment. We're needing to make upgrades to the audio video systems that are in the Supreme Court and the Court of Appeals courtrooms, as well as several conference rooms throughout the building. And, purchase a new server for our server room. The last item is subsidies to the counties for court interpreters. We did get some funding this year to get the court interpreter program off the ground.
Which we passed
which you
last year.
passed, and it's going, we're getting it up and running. This is to provide funding as a subsidy to the counties to help pay for those court interpreters, instead of putting that cost onto the counties. And it would be on an as-needed basis. If they need a court interpreter, then we would pay for that court interpreter for that local court.
Was that the intent of the legislation, that the state would pay for that? Or do you know?
I don't know. I can't speak to anyone's intent, but I think it's just, as we look forward for this program, that's where we would like to see it go.
Yep.
Thank you. How did you arrive at the 270,000?
I think we just did, if we paid one court reporter per court, what would that look like? And that's about what that cost would be.
Is the intent that they draw that down, or what? I mean, how
I think
are
there's
they gonna access?
access that
Yeah, are you
funds.
just doling it out?
No, sir, it would be a
Okay.
reimbursement.
Okay.
Right.
Based on what they've done.
Based on the hourly rate for whatever that certified court interpreter is, whatever that language is that they're having to interpret for, what is the hourly rate? And it would be on a contract basis.
So if the cost was incurred by the county, could we then reimburse them any portion of that amount?
Okay.
As we are seeing, obviously, court interpreters are in your counties who are not as wealthy as other counties, and it's just another hardship on those counties to fund those court interpreters. Off the top of my head, I don't, but I could probably get it for you in the next few minutes if you want me to.
Okay, so I had a question about, you mentioned intervention courts, and I know that there's been understandably a big push or whatever. Is that included in your budget request?
Yes, sir. And this year we did level funding for our intervention courts. We've been asking for increases every year. And so this year we decided to.
Yeah, that's why I'm surprised,
Mhm.
because the Chief Justice is stumped for that. You picking your priorities?
That decision was made prior to my accepting this position. So I can guarantee you next year that will not be the case. We will be asking for increases in our treatment.
So in your budget request, you're not asking for increases for the intervention courts?
No, sir. I think we were awarded 9.5 last year. I think that's what we are looking for this year. But if you find it in your heart to be generous, we will not turn it down.
That's why the chairman's sitting right next to me. So, all right, any questions from the committee? Senator DeBar.
Thank you, Mr. Chairman. I'm going to go back to the 4.36 million for the support staff.
Yes, sir.
Does that allow a trial judge to hire a law clerk and an administrator?
Yes, sir.
Do they hire more than just that, or is that what is required by law? How do,
Typically, in a county with in a district with multiple counties, there may be one or more court administrators, depending on the judge, but no judge would have two. And then there may be one or more law clerks. Sometimes they're able to share, some want their own. So typically, we see trial judges having a court administrator and a law clerk.
so no judge would get more if your request is meant more than 140,000 to
Correct.
spend on, they spend it how they want,
They spend it on, they can
they
split it
get-
up how they choose.
and they get nothing more than that.
Correct.
Okay. The 7% realignment, that's for staff?
Yes.
Is that, I think you, Senator Wiggins answered this. Is that for under SEC squared? Is that what that is, or?
Yes.
And that'll bring them up to what, the average, or is that going to put them above average?
I think we have finally met everyone at the average, and now we're looking to
Okay.
increase that.
Going to the 270,000 for the interpreters, what was the reimbursement asked last year for 23? What-
None.
Okay,
We were appropriated money to start the program, so
okay.
to hire a statewide facilitator.
Thank you.
You're
Nothing further. Thank you, Mr. Chairman.
Yeah, Senator Norwood.
Now, all of those at the 7%, all of those are state employees.
Senator, I'm sorry, can you
Sorry.
bring that closer to you?
All those are state employees, correct?
Yes, sir. Those are all in the garden building.
Okay. Now, drug court, yeah,
Yes, sir. The AOC drug court employees, yes, sir.
okay.
Yes,
All
sir.
right. Thank you, Mr. Chairman. Thank you very much.
Yeah, Senator Hickman.
Just a couple of questions. I wanted to go back to a question that Senator Barr asked to just make sure I completely understood. I understand that each judge, and this is back to this 4.3, each judge would then have 140,000 that they could kind of split up, but it doesn't prohibit judges from saying, like, if we have 4 judges in this circuit, they could all come together and say, we're going to hire 2 law clerks and 2 administrators, and they pull all of this together. But so it's basically, they just handle this however they want to within the circuit.
We put no restrictions on that.
Just one other question about the court interpreters. Has there been, I guess my question is, there areas or pockets of the state where this is more of an issue than other places and putting certain counties in more of a disadvantage than other counties when it comes to court interpreters and things of that nature?
Yes.
And from what you guys have seen since setting up the program, are there enough qualified interpreters throughout the state to do what we need them to do in the capacity that we needed?
Right now, no, but we are working diligently to recruit and train those interpreters.
And so with these funds, you're asking for help you do that?
No,
Okay, so you already have do you have a separate budget to do
just to fund that.
the training? Okay, because I just know I've been in some places where they had to continue things because they can't get a court interpreter, particularly in places where there's not a large population of whatever this language speaking people are, and they just have, they're tied up in other places.
Yes.
Thank you.
You're welcome.
I want to, on that issue, if I recall right from last year, I mean, you're asking for the appropriation request, but I think the enacting legislation kept it or raised it to 100. So do you know if there's a bill out there that's moving it to 140?
Oh, I do not
Okay.
know that.
And I think in my discussions, what I've heard is that it's the purpose for the benefit of the committee of this is it's the majority is for law clerks and all, because they're being hired away. Am I accurate in saying that?
Yes, sir.
Okay. Can you, and I know this may not be on your recommendation here, but can you talk about the status of the court reporters and what's going on in the state?
We have a significant shortage in court reporters. We're not training them fast enough, those that are even interested in becoming a court reporter. We have several counties who no longer have an official court reporter, so they're having to use temps to help out, and we do reimburse for that. We are looking for any kind of creative ways that we can get more court reporters into our counties.
So help educate me, because I was in a budget meeting yesterday and it was told to us that, by the way, it was the Workers' Comp Commission, if I'm remembering right. And they said that the Supreme Court has said that the court reporters can't freelance. Is that the case, which I assume it is, and if so, why?
Our Supreme Court has said official court reporters are not allowed to freelance. But an official court reporter may help out. Like if there's an official court reporter at the Workers' Comp Commission that is not working one day and would like to go help in Hinds County, they will be they will be paid for that work. That's certainly a rule change that I think the court is looking at, to have non-official court reporters freelance. That it just has not, as far as I know, it has not been voted upon or changed by the court.
Okay, and court reporters that are employed, I call it employed
Okay.
by the court,
Yes.
are paid through y'all?
Yeah, yes.
Okay, all right. Okay. Thank you. Any other questions? All right, thank you very much. Short and sweet.
I hope you don't mind that the chief did not come, but.
That's okay. You can tell him we missed him.
I'll be sure and tell him that. Thank you all very much. I will, yeah.
All right, thank you. We're going to, good, we're ahead of schedule, so go to the Office of State Public Defender. Andre, it's good to have you here. So we're gonna I'm going to turn it over to you and let you impress us.
Okay, thank you, Mr. Chairman. Andre Degree, Office of State Public Defender. I am the State Public Defender. We provide a variety of services. The State Defender was formed by a consolidation in 2011 of our Capital Defense Office, Indigent Appeals, and our Training Division. We still do all of those functions, and then we added parent representation to that. So the base level funding is we're not asking for any increase there. That's sufficient for the things that we have been doing. We can continue to do that at that level. We are asking for additional funding because we're asking and have consistently been asking for a long time, even before we were the Office of State Public Defender, to have a bigger impact for the state, not necessarily the office, but the state to have a bigger impact on indigent defense, particularly Sixth Amendment services, but also services in our youth court, which is on the delinquency side is also a constitutional mandate. So those service, primary indigent defense funding in the state of Mississippi is provided by our counties. And we're fairly unique. Most states do not require the counties or the counties to do it alone. We also, so that's puts us at the lowest per capita funding for indigent defense in the country, part because we're a poor state, but also because the burden is carried exclusively by our counties. And in some cases, I have no doubt they're doing the absolute best they can. In other cases, they may not want to do more, but we need to do more as a state. We are asking 4 primary areas. The primary additional funding we're asking for is building on, and we continuously are reevaluating how we can get to, or what statewide indigent defense system would look like. And we are continually changing what we're doing and what our plan is based on things that are happening in our world. Last year in HB 1020, the legislature recognizing particular needs in Hinds County included indigent defense in improving the overall justice system in Hinds County. And I would say, actually, we'll get to this at the end if I don't get y'all off schedule, or try to. The funding from the ARPA project, the backlog project, was the beginning of our changing and how we think now would work best to deliver indigent defense. So our first ask is essentially building on what we've done in Hinds County, or what you've done in Hinds County. The funding in 1020, we got about $450,000 to fund 3 attorney positions. We're funding those at a mid-level ADA amount. With that, the Hinds County Public Defender's Office has been able to restructure how they deliver public defense. It's not just 3 positions, but these are positions that we're paying more than what they had from the county. The counties, in almost every case, pay significantly less than the state scale, so significantly less than the ADA. And they consistently have problems of people leaving the public defender office to go across the street and work for the DA for more money. So we've got these 3 positions now.
Great. I'm sorry, that brings up a question. So are you saying, I'm just using this as an example. So a 10-year practicing attorney who is an ADA is making more than a 10-year practicing attorney public defender, because the ADA is being paid by the state versus the public defender being paid by the county.
That is correct. The
I'm going to turn it over to the chairman, the chairman.
Andre, thank you, and thank you, Mr. Chairman. I've got to run in a second, and a couple things I want to ask you about quickly before I go. I'm going to let him explore that a little bit further and want to hear the results of it, but the statewide public defense system, and I've been to a few programs, actually spoke at one a few months ago. You know, for a long time, the local attorneys, the word I heard in the bar was that, you know, we like public defense, but we also, this is how a lot of us make our living. And we're okay with the system it is. We like assignments. We like to be the judges to give us cases. It helps us, you know, piece together our budget for the year. What you're advocating is a statewide public defender program. I'm asking this as a question, which either just gives them more money to do that, or which actually puts the people, you employ the people ultimately to handle statewide public defense.
No, the current plan of what we're advocating and what we've started to do in Hinds County is it remains a local system, a local program, follows the existing statutes where the circuit judge makes the selection of the public defender, or if he's doing court appointments or contracts, that does not change.
Or where does, you just giving them extra money to do it?
Yes.
Or do you think you're getting, I mean, it kind of goes back to, and even some of the ones that have done public defense, I'm starting to hear a few people say, maybe we need to set up a system where they're the same people doing it because they're better. The appeals process works better because they know what they're doing. You know, prosecutors have even said it to me. We know what we're doing and they know what we're doing. So that way there's not as much where you got to deal with the problems because somebody didn't really handle the case as well as they should have.
So we do believe, separate from the budget, and Senator Wiggins and I have talked about this, we do believe there needs to be objective standards set. That's like, this is what a system, this is what attorneys should do in the system, this is how they should get on cases. And we're using Michigan as a model. Michigan still does, it's still local-based systems, but they have state standards, and then the need to meet those standards, the state funds the difference.
They have to meet a standard. All right. Then the second thing quickly was this youth defender program I see in here. Give me in 30 seconds, what is this?
So this is the mirror image of our parent defense program, which we developed when we started doing parent defense. Right now, what we want to do is hire an attorney who's an experienced youth defender, who's been out there working in youth defense, to come into our office. That would be a state employee, and they would be available assist. We already provide training. We do technical assistance now by an ad hoc committee that when someone calls with a question, we can refer it. We want somebody in the office, and then the addition of doing appeals, which we have the authority since 2006 to do appeals. Those of you who have worked in youth court, I have not. It's very different than criminal court. And we've got felony appellate lawyers who in the appeals office who are excellent. They've never been in youth court.
Okay.
And so we want someone to specialize in that.
Okay. And we can talk more about it later, but I've got to run. But thank you. And thank you, Mr. Chairman.
Thank you. You can proceed.
Okay. So jumping back to finish up with what we're talking about doing in is building off of with just some a pilot project, which has been talked about for several years, but we think Hinds County is not the only judicial district that's facing backlogs, that's facing in some cases a crisis in indigent defense. So we want to use that model to set up to supplement offices at that local level. Where we would go, we have no predetermined sites. It would be where the circuit judge and the board of supervisors want us to come. And we if we have more requests than two places, then we would have to set up a criteria to, like, how do we pick one over the other? But essentially to give them the opportunity, and particularly in North Mississippi where there's never been a public defender office, to give them the opportunity to establish an office and with the same positions that we're advocating for in Hinds County, both attorneys and support staff, particularly, we're talking about investigators and legal assistants. You just don't, Perry Mason didn't try a case by himself. You need support. So those that we're asking for just sort of the same thing we're doing in Hinds to be able to do it in a district in North Mississippi and a district in South Mississippi. Somewhat of a pilot project, but and just like what you did in Hinds County and say, this is in addition to, so they can't, the county can't say, oh, good, you come in with this office and we're gonna let all our part-time people go. They have to maintain the, and this is in 1020, they have to maintain what they have today in order to get the state money. So it is to build up what they have, not to replace what they have. So the second issue is the.
I'm sorry, I want to make sure I'm clear on that. If that wasn't in 1020 like that, what, they just replace it with the state funded position, is that correct?
They could have, yes. Well, if I had given them the money, because you gave me the authority to give it to them, I don't have to give it to them. But what we did was, but it's
I got
in
you.
there. That language is in there, and I think that's essential going forward to let the counties know this isn't letting them off the hook. Because now if you've got a county that's already funding, I don't believe there's a county or a district that is funding indigent defense at or more than the district attorney's office is making, which would be the upper limit on anything. You could under this framework, you could never pay more than the district attorney. So I don't think there's anybody anywhere close to what there's funding. Even Jackson County, which has more money than anybody and has the premier public defender office in the state, and everybody knows that. It's well-staffed and good attorneys who've been there a long time. They're still underpaid compared to the DA's office, but they're in the ballpark, so they're not losing people. But you want to keep what you have and build it up to something that's closer to parity with the district attorney is our goal.
So in a way, I guess you're modeling it so it's like the state through these positions are helping, I don't know, build it up, not replacing.
Exactly.
Sounds
Supplement.
good to me.
Supplement, not supplant.
Okay.
And it is what we do on a case-by-case basis in the death penalty cases. We come in, we don't take over the case.
Right.
We come in as their co-counsel on the case and work with the local office. So it's additional funding for the whole system. It's not a replacement of what they're doing at the county level.
But let me ask to Chairman Hobson's question. I mean, and I think where he was going was, so you think that works, that kind of model works versus I'm not going to say complete, but a statewide system employed where there's public defenders employed by the state and funded by the state?
I have become convinced that it is a better way, and it's by looking at the success that they've had in Michigan versus what like Arkansas, for an example. Arkansas went to, when Mississippi in 1998 was first talking about the statewide system, and it was going to be state employees everywhere. Missouri and Arkansas had already done that, and those systems are not functioning as well as they had maybe hoped and planned and dreamed of. Where in Michigan, where they took a different approach, one, they're more incremental in their approach, not as incremental as me. I've been doing this a long time, one little half step at a time. But they took an incremental approach and they did it with the local, leaving the ultimate decisions. Who are the lawyers going to be in the courtroom at the local level? What's the structure? What's it going to look like? So we have, and now there's research starting to come out on that supports this model working. And it's what we've done for different reasons in parent defense, where we were picking up pilot projects that were funded and run by the AOC and Casey Family Programs. And it just, where something worked in one area, didn't work in another area. So we have two completely different systems operating in Northeast Mississippi, where Lee County is doing one thing and all of the smaller counties around it are doing something else, because there's just, that's what the conditions locally allowed for. And so we think that's really, but if you have standards, then people, you know, if you have statewide standards, then everybody knows what to expect in every court in the state. And I believe, I'm now convinced, you can do that without the state taking over anything.
Did you have, yeah.
So
if you have more.
I think I covered the youth defense program, and it just, you know, it's something that's probably been neglected. It was, a report came out in 2006 that was critical of how we delivered indigent defense in the youth court area. It's also a constitutional mandate. And the legislature responded with, let Indigent Appeals, a brand new agency, do the appeals on that. When I took over as state defender, they had done one appeal and we've done one since. It's just not having a person there who can be working with the lawyer, with the local lawyer, to develop those issues, who knows, who has expertise in youth court, because it is different. It is not, you can get the best criminal defense lawyer in the state and stick them in youth court and they're going to be lost. Some of you have been in youth court, you know, maybe you're lost even if you've been in there, but it's different than criminal defense, and that's why we want a specialist there.
Okay, but let me ask you this then. The governor has put in his EBR funding with the idea of a youth court system that involves chancellors. Now, in Chancery Court, we know you have appeals. We know you've got a record. You know we got that. I know you may not know much about it, but let's just say if that's handled through as a chancellor, does that address that issue?
Well, I think the lawyer, we're talking about the delinquency side of youth court, and they usually use a referee, but if it converts to, it wouldn't matter who the judge is. The issue is who's representing the kid, and are they properly resourced, and with including having someone who can help them make sure they're preserving errors that can be appealed. And you know, we've seen it with the parent defense cases where we're now regularly have 5 or 6 appeals going at a time. And prior to our creating a parent defense program, we had no appeals. So we think that's working, and it can work on the youth side too. And I'm sensing that I'm out of time.
No, I just wanted to leave time. And I know Chairman Hobson wanted to leave time for the committee.
Yeah. So I would like to, we are in what you have on page 2 and 3 that I shared with you is the budget, what we're spending. It's not really a budget worksheet. It's a spending worksheet on parent defense now, where we're subsidizing local projects. And that's, it's growing across the state. I included the latest map on where kids in foster care are. This is something that is universally supported. CPS wants mandated parent attorneys, parent defenders in these cases. We obviously want them. The Supreme Court supports it. Now the foster care task force that reviewed the whole system has recommended that custodial parents have representation. So what there are a few other counties that are doing some level. Jackson County is the only one we know of that is every parent who can't afford a lawyer and wants a lawyer is getting representation in Jackson County. Not the other counties that are funding some level. That's probably not true. Where we're going with this is to help those counties, and the vast majority of them want this, and everybody who's looked at this system thinks this should be a mandated program. We think that once we roll out to that level, it should be state funding for half of it. And we're doing, again, this the same way. If the local, we sit down with the youth court judge and say, what do you want? And what can we do? And for example, in Lee County, Judge Bevel and I regularly argue about whether or not she should have a full-time lawyer and a part-time lawyer instead of 3 part-time lawyers. We still have 3 part-time lawyers because she gets to make the decision. But that's okay as long as the parents are getting represented. And you know, Lee County is a place you see on the map that have a lot of kids in foster care, and we've got to be helping areas like that. So we've been building that up over the last couple of years, and we're asking what we got approval. These legal service positions are successful because they can move, they can cross county lines, and they have people in their office, particularly who can work on like housing issues, which is people lose their kids often because they lose their house. And so it's just far more efficient to be delivering it that way as opposed to the part-time contractor. Most places, or even full-time, we do it both. Like Harrison County has a lawyer full-time in the county, and we have the Gulfport Legal Services Office that also can handle takes cases there, takes cases in Stone County where they otherwise have no appointment, can cover conflicts in Jackson, conflicts in Hancock. So we brought you last year the ask to do in Hines and the Golden Triangle. You'll see Lowndes County is one of the highest population of kids in custody, that we wanted to get up there and be able to help some of those parents. Lowndes County's got a part-time person with that number of kids. They need help. They need another part-time. They need, we think, somebody who can cover several of the counties around there. We put that on hold because there were 7 counties that have been receiving funds for several years from the Casey Family Grant through the AOC that was transferred to us a year ago. And then Casey cut their grant 2 years in a row. And so and they go on calendar year, so it hits us in the middle of the year. We knew it's coming. They told us this is going to be, you know, we've been here 12 years and we never stay anywhere more than 5. So we know we've gotten our money's worth out of Casey, and they're weaning us off, and it's hard. But we shifted, instead of starting up those legal aid programs, to funding the county programs to keep them going, because it's mid-year. It's 3 months into their year. So
Let me stop you right there. And I want to have time for the committee. So any committee members, that question, Senator DeBar?
So with the public defender program you were talking about, this still allows the senior circuit judge to appoint an attorney who might often, especially in rural areas, have their own law practice. They can do their law practice as well as be the public defender as well. That's not going to interfere with that ability of that judge.
no, it's the power of the judge to do it, whatever way he wants to do it. They set up the system as long as it's, we say in we have the full budget narrative attached here too. We say, as long as it's consistent with existing statute, and the existing statute, there are 2 actual statutes, either the ad hoc appointment, which from a budget management perspective, I'm not going to get into, although we do that some in the parent defense cases, it's a pain to try. You never know when when the invoice is going to come. I would stay away from that on the big scale. But what happens in most places are the contracts, and if that's, as long as it's the consistent with the statute, which allows for full-time or part-time, then they would qualify
Okay.
for, and, you know, only if, the only thing it gets complicated is if they went to, if it was going to be, because we're trying to encourage multi-county agreements, because rural counties are particularly unable to provide indigent defense. It would only it would only be if they wanted to do a full county, a full district, because I think the district defender would have to be a full-time position.
Okay.
But they still are allowed, and I know the DAs, I think maybe they got part-time now. They've been grumbling about the fact that I don't want to change that. I want to be able to keep, that
Okay.
would be a local
All right.
option.
Thank you. Thank you, Mr. Chairman.
You, anybody else? Senator Norwood?
Andre, regarding the $300,000 that asked to be reappropriated in the ARPA money for Hines County. Now, will stay with your office to provide support to Hines County, or would that be managed out of Hines County?
So the way the ARPA funds work, that's the project that began in 2022. That is actually through our office. So we set up an office. Now, we work with the county. This week, we had 3 trials. Our co-counsel in all 3 was the county public defender. The cases all come out of the county public defender's office. So we just function essentially as 3 additional assistant public defenders. They get, so the cases, they have remained on all of these cases, and we've made an appearance with them on the cases. But that is all, the ARPA funds come to us for administration. And the question I have with the ARPA funds, and I've asked the question to Elbow, I've asked the question to DFA, I've asked the question multiple times to Horn, who's the DFA contractor, giving us advice on, and I just want a definition of the word obligated. And because I know that ARPA funds have to be obligated by the end of this calendar year. And I want, do you have an answer? Oh, good. Well, maybe
Corbin,
not good.
would you like to answer?
I can do it later.
You can
Okay.
do it now. I'm prepared for the bad news, so you can.
I mean, they just have to be under contract
Okay.
or something along those lines. If it's for salaried employees, you can only pay them up to January of 2024. But if it's a contract employee, then you can pay them out throughout year. So if it's a salaried employee, you know,
We
you
could
get
change.
your paycheck in December, that's then obligated for for salaries. But if it's a contract, if you pay them for the whole year to do contractual work, then you can obligate it whenever you enter that contract.
Okay. So that's, now I want to ask for more money.
That's what I figured
yes.
based on reading it.
Yeah, so because we hired them as employees now. We have like our investigator and a social worker or actually contract workers because they're retirees and it just worked out better that way. But what has been appropriated up to this point, we believe that there's, and we're budgeting for this to stretch this as long as we can, we have enough funding in what's been appropriated the last 2 years, even appropriated and reappropriated for this year. If we reappropriate what we have today that we're not going to spend, that would get us through the end of the year. If And I think that the district attorney would also like to sit down. I don't know if in probably the chief justice and talk about a way to do that, because I think if somebody was able to continue, we're not going to finish up all of the cases that we have right now. We're still working on 2018 and 2019 cases. I mean, we've made great progress. We took on 350 cases and have 150 right now. And I know the district attorney's done more than that because they're also doing cases on retained counsel or outside counsel. So I think if this project can continue and it just has to be a contract with someone as opposed.
I'll let y'all can work with
We'll work-
Corbin on.
We'll work
on
that, we can work that out. So
Since Horn is the accountant, the auditor over all these funds, I mean, it's them that has the ultimate say. That's just what I read based on what the treasury guidance,
okay.
what came out. So they're the ultimate
Okay,
authority.
so the guidance
So
that
there
they've
was a
been
new
waiting.
guidance that was
Okay.
released on what is obligated.
Okay,
So I can send that to you.
okay, thank you.
Okay. Any other committee members have questions? Okay, we're coming up on time. So any last comments?
My last comment is my request for some funding so that we can pay interns.
I saw that.
There's not a public defender office. We don't have a problem at Capitol Defense. We have students who want to come from all over the country to work with us. And there are programs all over the country that will pay them. We're paying them $450, $500 a week for a 10-week summer internship. But students at Ole Miss and students at MC don't have, or Ole Miss and MC don't have that kind of money to pay them. And so they're faced with going to the Attorney General's office or leaving the state. And we have now a very well-organized student organization at Ole Miss that they would like to do public defense. And they're taking summer jobs in Memphis and Atlanta, and then they're taking permanent jobs going off to Kentucky and all kinds of places because we just don't have an opportunity for them here because they can't afford to keep paying their rent, paying their expenses and not getting something back. And so we're asking for a specific appropriation and we're not asking for them to come work at our office. They could if that's where they wanted to go, but they're public defender offices and these part-time public defenders, as long as they'll have to sign an agreement to say they're not going to work on their private for-profit cases. They're just going to work on public defender cases. But we had that experience. Tim Tucker in Pontotoc, part-time public defender, had an Ole Miss intern last summer who volunteered to work in his office, and it was very successful. So initially I thought it had to be full-time offices, but Tim showed that a part-timer could do it with putting in the right safeguards.
Great. Thank you very much. Very thorough. Appreciate that. Yep.
Based on, I guess, the definition of obligation, will you amend this request or will you get back to us?
I have a question. Maybe you and I should talk
Yeah,
because I've been told not to ask for ARPA money. And it was very nervous last year, but it arrived. So I was like, okay.
Let me let y'all talk off, but
Yes.
what he's saying is based on that, then amend the budget request so that we can be sure to capture it as it's needed.
Okay, we'll talk
On
about
that,
the
right,
specific, what we
Corbin?
specifically
Okay.
would want going forward to the end.
Right.
How we could structure that.
Yeah. Okay. Thank you very much. All right. We're moving to Office of Post Conviction. They why replace with Jim? All right, we're gonna turn it over to you. So you're welcome to give us your presentation.
There we go. I'm Chrissy Noble, and this is Brett Jurasset, who helps us with our budget with Cornerstone. So he's graciously attended with me, but has informed me he's not talking. So while I know some of the people here today, I don't know everyone, so I'll start just with me. I'm Chrissy Noble. I became the Director of Capital Post-Conviction in August of 2021. Before that, I was a staff attorney with the office. And before that, I was the Deputy Solicitor General to our current AG, defending a lot of the laws passed by this body. Before that, I worked for our prior AG, was in private practice at Phelps Dunbar for a long time. And then before that, worked for the federal government for almost 3 years. So I've done a broad array of work on all sides of the aisle, and that is something that is just deeply important to me as a lawyer. As for our budget, what we're asking for this year is really just level funding. We do have one issue with our special funds that we have carried over for many years that we haven't spent. So we always try to be really good stewards of the money and give back anything that, we're not spending. The reason we are asking to keep that $200,000 in our special funds as opposed to requesting a more general fund appropriation is just because of the flexibility and just the reactionary nature of the work that we do on a daily basis, which I'll talk about a little bit more in a second. But I wanted to just kind of step back and just talk about the office, because when I did become the director, I had a lot of people tell me that they didn't know the office existed, let alone what we did. So we were created in 2000, and we represent all of the indigent defendants, which is everyone, on death row. And we represent them per statute up until the time that they're executed, or they die of natural causes, or they get off of death row. So it's as I like to tell people, it is a long-term relationship with your client, as opposed to the short one that you see in other areas of public defense, where you're just rotating kind of in and out, other than the frequent flyers that I've seen many times. But on the handout, you'll see a chart that maps kind of how much our expenditures fluctuate over the years based on what really is a reactionary nature of our job, because there are so many times that I have no idea when the state's going to move to set an execution date. That's not something they disclose to me before they do it. When science is going to develop, when forensic science is going to develop, which has been a huge issue with us lately, when new evidence is going to come about. Those are things I can't predict and often need flexibility to spend the money. But unlike a regular indigent appeals attorney, which is kind of what you would have heard from right prior to me, post-conviction is purposefully not limited to the trial record, right? We are making sure that everything went right in the trial. And that does include an investigation that really is from ground up. So we do a complete new investigation. We very often present newly discovered evidence to the courts. Sometimes that evidence does include suppressed evidence, which often is just negligently suppressed, but suppressed nonetheless. Recently, we've had cases involving changes in science with bite mark evidence, ballistic evidence, microscopic hair evidence, DNA exonerating people. Those are all issues that come about in post-conviction pretty regularly, including in Mississippi. And often with post-conviction work, it seems like, okay, well, how many bites at the apple do you get? So I just want to take a step back and not, have any commentary on the law, but show how post-conviction recently, including in Mississippi, has been impacting people. And at the end of 2023, there was a study done just by the National Registry of Exonerations. There's not any argument by an attorney, which I appreciate argument on both sides, but just the exoneration registry. There's been 196 death row exonerations in the United States, just in the modern era of our death penalty jurisprudence. 7 of those have been in Mississippi recently. Those aren't cases where I would say, oh yeah, their constitutional rights were violated, but they're guilty. Those are actual innocent cases. And if you move back from that, since 1989, even discounting death row, there have been 3,000 people exonerated from crimes that they did not commit. All of those people were exonerated after spending close on average to about 20 years in prison. And the only reason they were able to be exonerated is through a robust post-conviction process. I say all that to say I'm a lawyer's lawyer and appreciate the law regardless of what it is, but I do think the importance of our office can sometimes be overlooked. And we are a very small office, and I've tried to limit, actually we've cut down employees. There are only 9 of us. There are 5 attorneys, 2 mitigation specialists, which have their master's degree in social work, 1 investigator who was a detective with JPD and worked on the FBI task force, and 1 paralegal. And I, as the director, take on a full caseload. So there's just 5 of us, including me. And those are just like kind of the importance of post-conviction. But as to like the flexibility to need to spend the funds, I do think since early 2023, I can give you 2 examples of things that I could not have predicted landing on my desk. One is an actual innocence case. Our office was originally conflicted out because the prior director worked on the case at another time when he was working for the court. So it conflicted the whole office out, and he was, of course, given another attorney, but of course not someone with a lot of resources. So I got a call about a year ago saying, look, I've really looked into this case. I think the man is completely 100% actual innocent. Can you take a look at it now that your office is not conflicted out? So we got appointed in that case about a year ago. And since that time, I feel like I have lived everywhere but here, working on the case, and we have submitted an actual innocence petition to the court that I firmly stand by, even as someone who's done this work on the other side. In October of 2023, we got appointed to another case that I was not expecting events to happen, but we get appointed on October 11th, 2023 by the Mississippi Supreme Court. 3 weeks later, the state moved to set the man's execution date. So at the time the state moved to set his execution date, I had not even met my client. At that point, I, of course, immediately drove to Parchman to meet my client for the first time. And we do go to Parchman about once a week. And immediately discovered that he had some claims that were going to require experts under the law, including intellectual disability claims and a potential claim for incompetency. So in a matter of 2 months, I had to get 4 experts in to evaluate my client in November of 2023 and December of 2023, that I never could have predicted that happening because he had a prior attorney from 2016 to October of 2023, but that attorney got disbarred and he was never appointed another attorney. So he was never able to present these claims until we got appointed in October of 2023. So without just like the flexibility to spend the money if we need it, I would not have been able to do a constitutionally effective job. And that's what people, I think, at least all can agree on for post-conviction, is that we want to end up saving the state money. And if it's not done right the first go around, it's going to go to federal court and they're going to send it back and we're going to have to do it all over again, which has happened not in recent years really, but in the past, especially before this office was created. But that I hope highlights just kind of why we need the flexibility to spend the money, as well as just kind of why it fluctuates from year to year.
Chrissy, so thank you. Yes, what you're doing is extremely important. And so thank you. It probably gets lost in some of the media coverage and all that, that we do this, we meaning as a state, do this kind of stuff. I wanted to bring up, so the request on the special funds, that was the sweeps bill, right?
Yeah, it's been
Yeah.
there for
It's been there for a while.
a
We're gonna leave that up to the chairman,
Sure.
Chairman Hobson. So, because I think that applies across the agency. So, does anybody, any other questions from the committee? No questions. So, look, I think what you're doing, thank you for I think this is the first time for me to handle this budget. So thank you for the presentation. And yeah, I think and appreciate you, as you said, keeping the staff down in the sense of managing costs and stuff like that. So that's good.
Well, maybe unfortunately for my clients, I just love the law, so they're just stuck with me on a lot of cases instead of hiring
Some tells
someone
me
else.
they get a good attorney, so, but thank you for that. So
Absolutely. Thank you guys for listening. I really appreciate it.
appreciate
It's
it.
Good to see you guys.
Thank you. All right, next we're moving on to the Judicial Performance Commission. Either one's fine. So when you're ready, you can proceed. By the way, I like the no kidding number fully staffed. I like that. Okay. Oh, is that what? Okay. Oh, okay. Bottom line up front. Got it.
Thank you, Executive Director of Judicial Performance Commission. And as you know, our purview is to not only prosecute administratively instances of judicial misconduct, but it's also to protect the judiciary from unfounded complaints of judicial misconduct. And probably we do more of the latter than we do the former. However, the former takes more time, energy, and funding to do, obviously. So just a look at what we have on the paper with the requested budget number, our number for total was 823 and change. Of that, 703 and change was for salaries. The distinction between that and the elbow recommendation is that we have one staff that is open presently. We were able, last year we had someone unexpectedly pass. So we had some expenditures that we had to pay out that we wouldn't have otherwise had to pay out if someone was actually retiring. So we, as an agency, tightened the belt buckle and said, okay, we're going to make this happen so that we don't have to go back for an deficit funding. We were able to do that. So I have asked of every person in the agency, myself included, to do your job and our office manager is the office manager and receptionist. Our investigator is our investigator and our chief information officer that stays up at night writing code to automate everything in our agency so that we run more efficiently and have less work to do. Our senior staff attorney is our senior staff attorney and staff attorney. I am the executive director, also known as the chaos coordinator, and I pitch in on every one of those or both, any number of combination of those as needed. We have incredible people there, and we have been able to keep those incredible people with an exception. We did hire someone for about 6 months as the staff attorney, and she could go to private practice and make more money, and she left us for private practice. So it wasn't a good fit, and that's okay, but we still have a hole there. And when we fill that hole, because I can't keep asking everyone to do twice their job for not even market value and expect to keep anyone employed there. But that being said, going forward, if we are to hire that person, we, no kidding, have to have the salary of 703,995. And if we use that number, then we're only looking at 25 grand to do everything else that we've got to do, that our agency is supposed to do. And obviously that number just isn't going to work. And it doesn't matter how much code or how much automation you do, that just won't get it. So looking at that, because I say that we're trying to pay closer to market value, a staff attorney with 15 years of experience, for example, the ADAs would be roughly $121,000. We're not even paying that. We're not paying anywhere close to that for a staff attorney. So we, no kidding, have to have what we're asking for the salaries there. But don't just take my word for what our office has done this year. I gave you the numbers there. We fielded 481 complaints in the last year, and that is up double plus some more change. So when I started as executive director, we were running 180 to 200 a year, and we are now at 481.
And how long have you been executive director?
When did COVID hit? 23.
So why the increase
Well,
of complaints?
one of the things is that we are very intentional about making sure the people who need to know that we exist know that we actually exist. Confession, I had been litigating cases for 15 years in and out of courts all over the place, had been a municipal judge and didn't know that judicial performance existed. That's a problem. So what we have done is we have gone out to Rotary, and by we, I say me, I'm usually the one that does those, go out to Rotary clubs and let the general population know who we are and what we do, because those are the people who were affected by judicial misconduct much more than anyone else. You know, the Joe Schmo general public is the person that is in front of a judge that needs to know if that judge has committed misconduct, who to tell about that. And they wouldn't know that without us getting out into the communities and letting people know who we are and what we do. So some of that is that. The other part of it, I think, is that we have made it so much easier to file complaints with us, because we don't want an instance of there being judicial misconduct and someone thinking it's too much trouble to come to Jackson, pick up an actual piece of paper, write it out, give it back, and then wait. And because our numbers are increasing and we're limited on staff, there's only so many that we can do at a time. So if one comes in today, it's probably not even going to be fully vetted for 3 months, maybe 4. So that's the increase for it. Of those 481 cases, complaints, initial complaints, 149 were investigated. Some of those, it's genuinely as easy as picking up the phone and asking the clerk to send a file. We look at the file, easy peasy, that happens. However, some of them are to drive to every corner of the state of Mississippi and talk to people, and you hope it's only one time that you've got to go, but it probably isn't. So we've got travel involved in that. We've got time involved in that. From those 141 cases, we filed 11 formal complaints, and those are actual, the criminal equivalent would be like there's an indictment. So we are proceeding with those cases, which means we have 11 cases on the trial docket. And anyone who has practiced knows that a case on the trial docket means that there are going to be some expenses. If nothing else, a court reporter and the witness fees and the witness travel, all of those things. So with 11 of those, we either have to settle them or we need you all to fund us so that we can actually try them, so that we get the results that we need to get. Again, for the general public. We've also administered 10 trainings. We have taken a community policing approach, again, with the idea that the best product that we can give the public is that the judge knows what they're doing on the front end of it, and we don't have to come in on the back end when they have already been harmed. So we take a community policing approach, and we teach the judicial ethics hours for all of the judges. And the last one is my personal favorite. We have fielded 3,363 phone calls on the office lines. Every one of our office has personal cell phones. These are not counted in that 3,363. There is not a state court judge in the state of Mississippi that doesn't have my personal cell phone. And that's on me, because if they want to get to the right answer, I want to help them. I want to help them. And if they don't care, well, they can be one of those 11 on there, and that'd be all right too. We don't mind doing that. So all of that being said, we, no kidding, have to have the 703,995 for the salaries. But again, that only leaves the 25 grand if we go with the elbow recommendation for that. So really the bottom line number is the 823,619.
So let me ask you a note here about authority for replacement of a vehicle. What is that?
That is an
Are you
ongoing.
without a vehicle?
We have a vehicle that now when you put it in reverse, 80% of the time it will go backwards. We have had that car. We have been asking for a new car for I don't know how long. And now the problem is that started with COVID, and we can't get a car that fits our needs from the dealership with any amount of money. There's not one that exists. So we frequently will use our own vehicles, or I use my own vehicle. I like to know I'm going in reverse.
Well,
If I
do
put it in
y'all need the
reverse.
vehicle?
We always need the vehicle, yes, sir, but that is not reflected in the 823.
You're asking for special fund authority.
That'd be great.
Okay,
If it's there, that'd be great. And I know that there's money in the special fund account,
yeah,
but that would be great, provided that we get the 823 out of the general, or general and special, but we need the 823 before we get an additional vehicle. Because
okay,
people are just more important than the car at this point.
I got you. Okay. All right, any questions? Senator Hickman.
Just a couple of questions for personal knowledge. I don't know. When you say formal cases and you file them, who hears these cases?
That's a great question. So our commission is made up of 16 members and alternates combined. From that, there will be a panel selected to hear the cases. They'll be the finders of fact, but that has been the same people that determine probable cause in the past. So what we have begun doing is taking prior commission members who know nothing about that case to come in and hear the case. And then we have one current member who's a non-voting member of that panel.
And so what's the average cost of like having a formal trial, like for these 11 cases?
You know, every lawyer likes this answer because it always works. It really does depend though. So you're always going to have the cost of court reporter, and that cost can vary based on how long the trial lasts. That's number one. Another cost is paying witnesses to drive in. If we've got a case out of DeSoto County, all of the witnesses are in DeSoto County and they have to drive in here. We owe them a witness fee, and we also owe them the mileage for appearance. So it could be anywhere from a low of $300, which I don't think it's ever been that low, to a high of, you name the number.
One final question. So I'm guessing these 480 complaints, you look at whatever documents, you say they're unfounded, and then you have like 149 you have to investigate. Where are the bulk of these complaints coming from? Like what court system are the bulk of these coming from?
So last year, the Chancery Court actually surpassed the Justice Court judges. Typically, because the Justice Court judges are larger in number, we get a lot from there. But think about it. There were very few courts that were going on during COVID. One that couldn't slow down was Chancery Court matters. And those are the people who have their children taken away and you're messing with their family. So it's not really a big surprise that they get it now.
Okay, anybody? Senator Barr.
So you've been in this office about 4 years now since COVID,
Yes, sir.
and you've doubled the number of complaints have doubled since
Yes,
you've
sir.
been in. So what type of cases? I read something the other day about a case. Was that something your office handled? Is that?
Which case is that?
The one I saw with this Moore, Carlos Moore. Was
Yes,
that
sir.
your office?
Yes, sir. That
Is that,
case,
did that take a long time? Was that expensive? Is that?
yes, so Judge Moore in that instance, and this is public record, so I can speak about it now. Otherwise, I would not be able to speak about it. Right. Right. So before anything goes to the Supreme Court, it's confidential and I wouldn't be able to discuss it. But because it has gone to the Supreme Court, I can now discuss it. And the filing showed the timeline of events. So this particular complaint against Judge Moore was really a continuation of a prior complaint that had already been resolved, plus a few others as we go. But that being said, as I recollect, it was a 2021 case that was finally resolved. So most of them take 2-ish, maybe 2.5, 3 years.
That long for?
Yes, sir.
Okay.
Unless they're resolved. I mean, if it's something that we serve the judge with the formal complaint and the judge says, my bad, I didn't know that was wrong. That's an easy enough handle. That one's not going to be multiple years and it's not going to be that expensive to handle because it's really
So
going
what
to
can the
be.
range of punishments be? If there's a formal complaint, there's a finding of guilt or admission of guilt, what's the range? Is that determined by you or is that the commission? How's that work?
It's determined by the panel and everything that the panel decides is then sent in the form of a recommendation to the full commission. If the full commission accepts it, then it is sent in the form of a recommendation to the Supreme Court, who either says, yes, you got it right, no, you didn't, we're going to up it some, or no, you didn't, we're going to lower it some, or you just got it wrong.
Well, I've been sitting on your budget hearings for ever since you've been on the director. You've asked for that vehicle every year.
We're going to get it one year. We're gonna get
So
it
maybe
one
we can get a vehicle for you or your staff. And you've never asked for any increase in staff, but it seems like it'd be justified or warranted potentially. Is that, would you, if the money's there and the
We
chairman
would
finds
love to
it?
do that. We actually accept externs through the law school because we think as, number one, civil servants, but number two, lawyers, it's our job to bring up those coming behind us and show them what right looks like. So we always accept interns, externs, anything that we can get for free because we don't have the money to pay them. So absolutely, we would love to do that.
Okay. All right. Thank you. Thank you, Director. Thank you, Mr. Chairman.
Yes, sir.
Real quick, we got right at time.
I mean, you handle elected as well as appointed.
I'm sorry, say that one more time.
Elected as well as.
Yes, sir. We handle every type of state court judge within the state of Mississippi to include the Supreme Court and the Court of Appeals.
So thank you. On your, if you'll note this down or so, can we get a breakdown of the salary, the 703,955 number? And get that to us, please?
Yes, sir.
Unless you have it here with you, but
I do not have it here with me.
okay, if you can get that to us, that would be great.
Yes, sir.
Okay. All right, thank you very much. Appreciate it. All right, we're returning to the DAs.
Oh, wow.
Okay, we're going, so Mr. DA Parker, so it's your time to shine in front of us.
And
And-
I only, Mr.
And
Chairman,
Mr. Degree showed you up, so you can imagine this is a courtroom.
I was listening. I was
Okay.
listening. I appreciate it, Mr. Chairman, to each of the committee members. Before I get into the actual budget, I think it's best to understand how we're not the typical agency. We have 23 separate independently elected district attorneys. Each district is made up of anywhere from 1 to 7 counties. The budget, when you start looking at 93% of the budget request goes to statutorily allotted state employees. That's assistant district attorneys and investigators. Each of those 23 districts has a different number of state employees, depending on population size and depending on caseload. So I'm here as the president of the Mississippi Prosecutors Association, but each of those DAs really is a mini agency head for that. As far as the budget request itself, as you can see, of the 31,612,000, 93% of that directly goes to the salaries that are allocated based on statutes for each assistant district attorney and investigator. As far as the travel and the office expense, so each DA's office by statute is given $50,000 as an office expense, plus an additional $4,000 per ADA, which takes into consideration the size of the office. As you can imagine, just for me, the district attorney for Harrison, Hancock, and Stone County, a $50,000 office budget does not go very far. We are lucky that the counties help to supplement a lot of that. They help to provide us a place to work for a lot of us. They also help to provide other employees. The $50,000 office expense also is not just directly given to the office. This is something that's reimbursed. So there's a check and balance for the 7% of travel and office expense. We expend that, and then we turn in all of the receipts and the request for the state to reimburse us, which I think is always a good check and balance. It's not just given to the individual office to spend beforehand. So when you look at it like that, with 93% that goes to salaries, and then the 7% isn't given directly to us, we have to ask for reimbursement. That's the check and balance of that. And at this point, we're not asking for anything above and beyond. There is something for ADAs, it's a tiered approach. For somebody who's over 5 years, they get this amount. For somebody who's over 15 years, and that's what that additional monies is for. And then there's also a request in there for Hinds County specifically, they were allotted 2 other special assistant district attorneys, and that's making up for that. But with that, I'm happy to answer any questions from the committee or Mr. Chairman.
Okay, so are you asking for an increase from last year? If I'm reading it right.
Yes.
Yeah.
Yes, there is a.
And the increase is for what?
It's for the ADA's step.
Okay,
So
for the step raises.
So we're required to turn in how many ADAs we have and where they are on that tier. And if they go above 5 years, their money.
Because they automatically get a raise, or at least that's how it's structured.
Yes, sir. Yes. Sir.
Okay. So that's the salary increase to
Yes, sir.
pay to, because they've reached those
The
levels.
tiers.
Okay.
Yes.
I'm just, okay. So we did the additional ADAs last year.
Yes, sir.
Okay. So have those been taken into account?
Yes, they have. Those
Okay.
were taken into account. They were already taken into account before. This isn't for those ADAs that were given out last year.
Okay. I know we talked about that obviously a lot last year, so it's still the position that I think we ended up with 12, 13 or 14 across the state.
Yes, sir.
And, is nobody's saying we don't need them anymore, are they?
I think that's, look, we're constantly looking at population and case management, and that's something after COVID threw a spike in there, and now we're just seeing how that's shaken out. There was a spike immediately after COVID because there was a dip during COVID. Different districts, like I said, we have 23 separate districts. In my district, the courts never shut down. They shut down for maybe 2 weeks and then they kept going. There are other districts that are facing a backlog a lot more. So when it comes to the request, I think what happened last year is I think the right areas received an additional district assistant. And now we just have to see how that plays out as far as, is the backlog gone? Are the cases increasing, decreasing, things of that nature?
Are y'all including investigators in this
Yes.
budget request?
Yes,
Okay.
the investigators are statutory allotted, and that this budget pays for those investigators. Each state by or each district by statute is assigned a certain number of state investigators. Now, we can go to the counties and request additional investigators, but it has to be funded by the county or some other source. So everything we're asking for is already in the statute.
Okay. So the district attorney, and I'm not saying anything that's not, can't be said, but the district attorney for DeSoto County came to see us. There was appropriation last year through I think it was ARPA funds, capital expense. It's not working out. It's been, a good case was made that DeSoto County needs that funding in those slots, but they need additional slots. Have you discussed that? Do you know about that?
I do not. I'd be happy to reach out to the new DeSoto County District Attorney, who I'm thinking just took office January 1st. I have not had the opportunity to, or he hasn't called me.
I think he's still getting his feet wet.
I know that we have talked with his office as he's getting his feet wet.
So, and I noticed, let's see, and the new 23rd district is where? Is DeSoto. So, okay. What, can somebody answer that? The two increase for that 23rd district?
Yes, sir. So the 275,000 that you're seeing as an increase to this budget was 275,000 given for the costs associated with the beginning of the 23rd district startup costs via HB 603 last year, and was sustained here as those costs.
Got you.
But the DAs are budgeted in a lump sum.
Right. All I will say is this is what happens when you create a new district outside the normal course of events. Okay. So this is what happens. And so, yes, a plea was made to us because of this funding that occurred through the capital expense fund, because it's a 1-year basis and you can't really hire an ADA on a 1-year contract. So what the request is that they have an additional 3 ADAs, because as it was explained to me, when this district was created, it was, they were left holding the bag without enough resources. If you want, it would probably help the DAs if you talk to them. I mean, I can do that because that's what they were getting at.
No,
I mean,
absolutely.
and based on, and DeSoto County and Harrison County have generally the same amount of population and cases. And I think Harrison County has 12. And the way the way it was shown to me, which in the statute, DeSoto has 5
Mhm.
with the same amount of cases and people.
Right. We also have Hancock and Stone, but I'm not saying anything.
Okay,
to
well, that's a
disagree.
good point. That's a good point, but they're the fastest growing in the state. So
I would
anyway,
agree.
he's still getting his feet wet.
But I'll be happy to call him.
And what I was saying is, Corbin, that if we do that, it needs to go through this request, through the appropriation DA budget.
So we'd need to go back and amend our request.
Well, that's
to
where I'm going.
reflect.
Yeah, and I'll talk to
Okay.
them about it, but that may need to happen.
And I'll be happy to reach out to him. That's what, sometimes it's odd for me to be speaking for the other 22 district attorneys.
No offense to y'all, but hearing from 22 district attorneys that I prefer one right now. So, okay. Okay. Any question? Yeah, Senator DeBar.
Thank you, Mr. Chairman. So in your DA's office, the state pays for just about everything except for maybe the building or the office that you have, or what does the county pay for, I guess? That'd be an easier question to answer.
So it's interesting because we have the state employees being the district attorney. Some of the assistant district attorneys, a majority of them are paid by the state, and the investigators. But I'll just tell you, in Harrison, Hancock, and Stone County, we also have county-funded assistant district attorneys, and we have county-funded investigators.
And why is that? Is it because of the caseload, or is it just because of?
Absolutely. It's because of the caseload, and this allows us to be able to process the cases for those counties in the manner that they want it. In addition, a lot of our clerical staff are paid for by the counties. As I stated, the salaries are strictly for assistants and investigators. I have a worthless check division. I have a diversion. I have different clerks for each of all of those are paid for by the county. Because the office expense of $50,000, well, we all know that if you have to pay salary and fringe benefits, that would easily eat up one clerk. So, and I know from other DA's offices, they're not as lucky as we are where the county has space for them to work out of. So I feel very lucky for Harrison, Hancock, and Stone that our office expense, it goes, because once again, we have to turn in those reimbursable expenses. So, I mean, that's for paper, that's for Blu-rays, for Discovery, that's for copying, that's for Westlaw and Lexus, things of that.
Is that evenly split between the counties, or it's just at the location, like Hancock County, does they pay for all that office, they pay for that, or how does that work?
Well, it really depends on the size of the office. So our main office is in Gulfport, where we have a lot more employees there than Hancock. Over in Hancock, we have 2 ADAs and we have 2 clerks, 2 office. And so their budget and what they're needed is a lot less than what Harrison County, which has Gulfport and Biloxi.
Okay. So with the population shifts and, the potential this year, as you're very well aware of, redistricting and all that stuff, has the DA's Prosecutors Association submitted anything as far as, hey, we need additional DAs for our offices, or are you guys asking for more other than DeSoto, I believe?
Yes. We had that discussion, I guess it was last year, and this year we're not requesting anything. We're going to allow what we were given. Let's see how that works. Let's see where we are at. And we also knew that there could be redistricting conversations. And so we didn't feel it was prudent this year to have any discussions with that.
All right, thank you. Thank you, Mr. Chairman.
Anybody else? Mhm. Okay, that was short and sweet. Thank you very much. And with that, that will conclude subcommittee hearing. Do I have a motion? Rise, oh, sorry, right. All in favor, say aye. Thank you.